Hello, guys. Greetings to everyone. We're going to continue with our lesson in administrative law and administrative litigation. And the topic for today's lesson is administrative liability. So, in today's lesson, we're going to be looking at administrative liability, and this is going to be the first part of our lesson on administrative liability. The second part will be the principle of strict liability. So in today's lesson, we will start with the definition and the purpose. The definition, what is administrative liability? Then we'll look at the type of administrative liability, which include liability due to fault and liability without fault. Then we'll proceed with the procedure for claiming administrative liability and the exceptions. Then after that, we'll look at the importance of liability or importance of administrative liability, and then we'll conclude. And now in our next administrative law class, we'll look at the principle of strict liability. So now, what is administrative liability? Administrative liability refers to a legal responsibility borne by the administration. The administration here refers to any state person, the state authority, a local council, a public establishment, and so on. And so administrative liability is a legal responsibility that is borne by an administrative authority that has caused damage or prejudice to citizens. So this damage can be caused as a result of an action of the administration or by the omission of the administration in the performance of their public duties. So now I want you to take note of some things here. The first thing is that for you to hold the administration liable, you need to number one, you need to make sure that the prejudice that you have suffered is as a result of the action or the omission of that administrative authority. And also, that action or omission should be in the performance of his or her public duties. So, a Dio in his house, if a Dio come back to his house and cause prejudice to you as a neighbor in one way or the other, you are not going to take that person to the administrative court because he is a Dio. It becomes administrative liability only when the person has done that in the course of performing his duties as an administrator. So that is it. Administrative liability. And then what is the purpose of administrative liability? It is simply to ensure that public authorities are accountable. And not just accountability, but also that people or victims of administrative wrongdoings should have compensation and should be redressed. Meaning that the administration has wronged you, you should be compensated for that. The point is, according to the Constitution, we have to contribute in an equitable manner for the development of the fatherland. So one person should not suffer more than the other person simply for the country to be developed. So, for example, we want to construct a new road that Cameroonians will use. And then that new road is covering your about 3/4 of your land, which was your only asset. Meaning that you have just been used as a sacrifice for the development of the fatherland. So you need to be compensated for because of that. Administrative liability is rooted and enshrined in the Constitution of Cameroon 1996. The principle of administrative justice, state responsibility, and the rule of law. Now, the court that has the competence is known as the administrative court, where you can hold the administration liable. So Now, what are the types of administrative liability that exist? There are only two. We have administrative liability due to a fault and liability without a fault. This means that we're going to start with number one, administrative liability due to a fault. This means you are holding the administration liable due to a fault, something that they have either done or they have not done. What I mean is, this liability can arise as a result of an action or omission, the commission of a fault by the administration. It arises when the administrative authority or administrative agent or administrative body commit a fault that has caused harm to the third party. These faults can either be personal or in-service, service-related faults. When we talk of personal fault, we are talking about faults committed by public authorities in their private capacity as John, and not as, I'm saying if his name is John, he has committed that as John in his private capacity, not more as a Jew. He has committed that as Stephen, not more as a mayor. So here we talk of personal faults. Number two, we talk of service-related fault when this is being committed in the course of exercise of his duty. So here, it can be as a result of illegality, meaning that his action was illegal, or negligent, meaning that while carrying out his duty, he neglected some things which cause harm to you as an individual. So an example, you have mismanagement of public funds that has caused financial loss. That's an example of a service-related fault. Unlawful arrest of individual, seizure of administrative, a seizure of properties by administrative agents, and so on. So those are examples of administrative liability due to faults, either by reasons of negligence or illegality. So another thing is when there is something that happens and that mandates the authority to act and the authority never acted, we talk of liability due to omission. So it can either be by way of an action or an omission. For example, if a traveling agency that carries people from one place to another, if two vehicles, let's say there had an accident that took the life of about 140 Cameroonians, and the Minister of Transport is quiet about it and is not taking any measure to redress it, then he is liable due to omission. So that's the point. We are talking about liability due to a fault when the administrator is on the wrong, and then as a result, you that have suffered prejudice, you should be compensated. Then the second type of liability now is liability without fault. So the point here is that the administration may be held liable even without them committing a fault. Without them, they have followed the law in the exercise of their duty. They were very careful. There's no trace of negligence at all, but they can still be liable. So when we talk of this kind of liability, it is to the effect that when the administration has carried out an activity, it can either be risk-based liability or specific sacrifice or special sacrifice, where an individual suffers unusual harm for the benefit of general interest. The only person who has to work for general interest is the administration, not an individual. So when an individual sacrificially suffers harm for the benefit of general interest, that person deserves compensation. And as a result, the person can hold the administration liable. Yes. One person cannot suffer for the building of the fatherland alone. That is the point. And then we have risk-based liability when public authorities, they involve inherent dangers That means use of weapons, hazardous infrastructures, vaccines, and so on. For example, the injury during a public work project that caused an injury to someone. When I'm saying injury, I mean harm to someone. That's an example of what? A liability without fault, because the administration has not violated the principle of legality, neither negligence, neither public interest. So as a result, the administration is not at fault, but the administration is still liable. The falling of electric pole that has caused damage to people living in a particular area or to a particular person. So based on social justice and equity, individuals should not suffer alone for the benefit of all. So that is the reason why the administration can be held liable even when they have not committed a fault. Because according to the principle of social justice and equity, one person cannot suffer for everybody to enjoy. Now, after looking at this type of fault, I believe by now you understand what is meant by administrative liability. You also understand what is meant by liability without fault and administrative liability due to fault. Now, what are the conditions for you to engage in administrative liability? Number one, there must be the existence of a damage. Something must have been destroyed. Something, either it can be material, moral, or physical damage, but something must have been damaged. An injury must have been caused. So the first thing you present is the injury. You present the harm that you have gone through. You present either a physical or moral, psychological or physical harm that you have gone through. Then the second thing is that you have to attribute that harm to an act or an omission of the administration, meaning that you have to link it. You have to present an administrative action or omission that that has caused you to go through that harm. So there must be a link between the damage you have suffered and an administrative action or omission. And then the last thing is that even though there is an administrative action or omission, you must also be able to show that the damage has been caused directly or indirectly by the administrative conduct. So there must be a causal link. You must show that this is actually what caused me to go. This is what caused my house to burn. You must prove that this thing directly or indirectly caused damage to me. You must be able to prove that. Those are the conditions for you to hold the administration liable. Now, when you have succeeded, but when you are sure that the administration is liable, you can now come before the administrative court. And what are the procedures for claiming administrative liability? The first thing is the pre-litigation phase, meaning that you don't just carry yourself to court. The very first thing is when an administrative authority has when an action or omission of the administration has caused you harm, you have to first of all claim for compensation to the relevant authority, be it the minister or the council or the person that has caused you to go through that harm. You have to claim for compensation. You submit your claim. You have to write a claim and submit to the office of the administrator that this is what has happened, and so I am claiming compensation. It is when that person has not reacted that you can now go ahead to the judicial phase. So you cannot carry yourself to the administrative court without a pre-litigation complaint that you have placed at the administrator's disposal. Now, after the second, if there is no amicable solution that is found to your problem, then you can now come before the competent administrative court. And then when you come to the competent administrative court, according to law number 2006/022 of 29 December 2006, that set up the organization of the administrative court. You can come to the administrative court and you will have the burden of proof. And the burden of proof is for you, the burden of proof lies on the victim, you that have suffered the consequence of the administration's action. The burden of proof lies on you. You have to prove that the damage exists. You have to prove that you have to prove the fault of the administration, either by action or omission. Then you have to prove a link that have suffered this because of this administrator's action or omission. But now, even when it comes to you proving, yes, when it comes to the administrative court, like I said, you have to prove, but there are still exceptions. There are some things that are caused by what is known as force majeure. Force majeure is a legal term that refers to act of God. Things that are only possible, things that occur by nature. We call them act of God, and in law we call them force majeure. For example, the administration cannot be held liable for unpredictable circumstances or things that cannot be reversed, like natural disasters. A mountain has erupted and then you want to hold the administration liable. Is the administration the one that caused the mountain to erupt? Answer is no. Flood has occurred in a particular place. And you know, flood is a natural disaster to an extent, even though man-made to an extent, based on the way the people in that place have been treating their sewage and dumping waste. It can cause flood. But normally it should have been natural. So when such natural disasters, some things like landslide occur, you cannot hold the administration liable for the damage that you have suffered, because it is force majeure. Then also, there could be third-party intervention where the administration will no longer be liable. If the damage is due to an external agent, the administration will escape the liability. And the third is immunity of certain sovereign acts. There are some diplomatic acts, diplomatic decisions that the administration can take that will be immune. That when they take that decision, no matter what you suffer as a result of that, you cannot hold that administrator liable. There are some administrative acts that are immune. There are high levels of administrative acts. They are exempted from administrative liability. So it's good for you to know. Before we look at the importance of administrative liability, let's look at the case of Cameroon. When you read the Cameroon Constitution 1996 at the level of the preamble, you see that the Constitution protects the right to fair hearing and redress against administrative abuses. So it means that the Constitution, our Constitution, promote or it protect the right to a fair hearing. So that is a plus or a way towards administrative liability. Meaning that when you come before the administrative court, as a citizen, they will not simply look at the fact that you are just a policeman, but this person is a mayor. You are just a doctor, but this person is a governor. You have the right to a fair hearing. Then according to the law that organizes the administrative court, which I've mentioned above, law number 2006/022 of 29 December 2006, that law organizes the functioning of the administrative court. And also, on daily basis, or weekly basis, monthly basis, you have administrators that appear before the administrative court and their decisions are being cancelled. And they are being given injunctions and so on. So it simply means that citizens in Cameroon can have trust for institutions in such a way that when their rights are at stake, when their interests are at stake, or when they have suffered prejudice as a result of administrative action, they can challenge such decisions before the administrative court. As if that is not enough, We still have uh, CONAC, for example, the National Anti-Corruption Commission, and even the Supreme State Audit. They are there to prevent administrative damage because they have a preventive, they are there to prevent corruption, mismanagement of public funds, and so on. They have an oversight over administrative institutions. So they are there to make sure that the administration is carrying out what is known as good governance. So at the end of all this now, what is the end result? What are the importance? The importance is that citizens are their rights are going to be protected. We have the protection of the rights of citizens. Protection of citizens from the abuse of power and arbitrary governance. Also the protection of citizens from abuse of discretion by the administration. It encourages professionalism and caution. By the time you know that they can hold you liable for your action, it means that you will simply take care by the time you are acting or omitting. It also enhances trust for institutions. You can trust the governor now because you know that even if the governor acts illegally, you can challenge his decision at the administrative court. Then it also provides administrative justice to the people of Cameroon, as well as fairness. The fact that you can challenge and administrate the order or the action of an administrator before the court, it should make you feel like a Cameroonian. It should make you feel like someone in his or her own country. It should make you feel like a king in your country or a queen. So, administrative liability ensures that the administration, while exercising their public duty, does not infringe on citizens' rights without consequences. So, administrative liability is a cornerstone of public accountability. And it's very important. It's very important. So you need to understand this topic very well, and in case you have challenges, you ask your questions for clarification. Like I said, in our next administrative law class, we'll look at the principle of strict liability as it was applied in the case of Rayland versus Fletcher.